Constitution designed the order of things. And by constitutional design, the judiciary must rule as it should, even when, and inevitably, it will have to say what acts transgress constitutional boundaries. Now, the repercussions and the reactions of such pronouncements are already beyond the control of the judiciary, meaning it should not shirk from its constitutionally sworn duty, even if it may result in inconvenience. Does it have, therefore, a duty to mend ties with whatever party the inconvenience has surfaced? I think you already know the answer to that. When you are upholding a constitutional duty, then you must stop at upholding it. To add on to it is something else. Now, within the judiciary, we have always had divided cases, but these cases, if you are going to track, are the exceptions rather than the rule. In more cases than not, even in the most controversial cases, you would either have consensus or near unanimity. Now, I think it is incumbent upon any member of the judiciary, of the JBC, whether that member is the Chief Justice or a regular member appointed to represent a certain sector by the President, the Secretary of Justice, or the representative of Congress. It is the constitutional duty of that person, the moment that that person is convinced that there is a basis to raise an objection, to raise such an objection. And it is incumbent upon the Chief Justice to show that there is no hesitancy in doing a sworn constitutional duty. Especially if you will remember that I had made a call to the Philippine Bar Association to help us in our goal of reforming the judiciary. The people must be convinced that it is duty first that overrides all other considerations. Inconvenience, awkwardness, difficulties, these are to be set aside because precisely I think the reason why there is not sufficient faith in the rule of law is because there is inconsistent adherence to constitutionally sworn duties. Thank you, Buena.
Thank you. Buena, are you asking your second question now or later? Although anim na yung binilang ni Chief kanina.
Later.
Later, okay. For her first question this round, we call on Leah Manialak del Castillo.
Good afternoon, ma'am. Ma'am, this morning in an interview over the radio, the President said that he's open to charter change if only to clip the supposed meddlesome and overreaching power of the Supreme Court. Would you say that the SC's power of judicial review is already too much to a point that it tends to threaten the power of the other branches of the government?
The Chief Justice does not respond to political questions, and it should not, because that is also partly political and partly an interpretation of the Constitution's definition of our jurisdiction. So because we usually define our jurisdiction in the most important constitutional cases that are coming before that, I would not want to preempt such a question. Now, I cannot give an opinion on another person's opinion, even if it's the President's, because out of respect for these important public officials, I will have to